ChatGPT's analysis of the biases and fallacies and anything else, along with facts, double-checked, because we can't have hallucinations, of Governor Greg Abbott's letter to the mayor of San Marcos. First, the assertion of anti-Semitism in the resolution. The claim: Governor Abbott's letter claims that San Marcos's City Council's proposed resolution calling for the transfer of sovereignty over Palestinian territories and an embargo on Israel may be implicitly anti-Semitic and violates Texas law. There's bias in that. The letter assumes that any policy critical of Israel automatically leads to accusations of anti-Semitism, conflating criticism of the Israeli government with hatred of Jewish people. This is a common rhetorical device used to discredit criticism of Israel. Fact check. The claim that the resolution is anti-Semitic is not inherently true. International law allows for criticism of Israel without being anti-Semitic. A resolution that calls for political actions, such as sovereignty transfer for Palestinians or an embargo, does not automatically indicate hatred of Jewish people or anti-Semitism. Anti-Israel policies or positions that target civilians or promote violence, however, may be deemed problematic. To label criticism of Israel's government as anti-Semitism without further evidence is an overgeneralization. The claim about the unequivocal condemnation of Hamas. The claim: Abbott asserts that the proposed resolution condemns targeting civilians but fails to specifically condemn Hamas's actions during the October 7th attacks. The bias: the statement selectively emphasizes one part of the resolution, the condemnation of civilian targeting, and omits the broader context, which may be more complex. It assumes that because Hamas isn't specifically named, the city council may be neglecting to address its violent actions, thus reinforcing a negative perception of the council's stance. The fact check: the resolution may not directly address Hamas, but this does not necessarily invalidate its condemnation of violence. Many political statements or resolutions aim to focus on the broader humanitarian concerns rather than focus on one group. It is important to note that multiple parties are involved in the conflict, and addressing one side exclusively, either Hamas or Israel, often oversimplifies the situation. The accusation that the resolution does not unequivocally condemn Hamas is a narrow critique without addressing the full breadth of the council's position. The alleged violation of Texas law. The claim: Abbott claims that the proposed resolution, which calls for an embargo on Israel, violates Texas law, Texas Government Code subsection 2271, which prohibits governmental entities from boycotting Israel. The bias in that: Abbott's letter frames the resolution as an explicit violation of state law without acknowledging that local governments might have some leeway in terms of expressing political stances. This is an attempt to delegitimize local political actions based on state law. The fact check on that: Texas law prohibits governmental entities from entering into contracts with entities that engage in boycotts of Israel. However, whether a city council's resolution calling for the reallocation of funds or the imposition of an embargo constitutes a boycott, under Texas law is open to legal interpretation. The Texas law specifically applies to contracts and economic boycotts rather than political resolutions or symbolic acts. It is not automatically clear that this local resolution would constitute a breach of the law, as Texas law is focused on boycotts in contracts and state funding, not public resolutions or statements. Reallocation of funds. The claim: Abbott's letter suggests that San Marcos City Council's proposed resolution seeks to reallocate funds from Israel's military to domestic priorities, and that this constitutes a penalty or boycott of Israel. Bias: the letter frames the reallocation of funds as a penalty, implying that the city council's intent is to harm Israel economically. This language simplifies the situation and focuses on a negative connotation while ignoring the broader goals the council might have, such as redirecting resources toward local needs. The fact check: the resolution may indeed seek to redirect funds, but that specific language of penalty is not substantiated by the content of the resolution. Redirecting local tax funds to domestic priorities doesn't necessarily qualify as a boycott. Boycotting typically involves refusing to engage in economic transactions with a specific country or entity to punish them. A reallocation of funds within a local government's budget is different from the economic actions that would qualify as a boycott under state law. There is no definitive evidence that this reallocation is intended to harm Israel economically. The threat to terminate grants and compliance. The claim, Governor Abbott threatens to terminate state grants and withhold future agreements if the city of San Marcos passes the resolution alleging non-compliance with state law. The bias. The letter uses a strong and assertive tone to threaten actions that could have serious consequences for San Marcos, creating an image of state government standing firm on its stance against boycotting Israel. The tone is punitive and one-sided, without acknowledging the possibility that local governments have a degree of autonomy to make resolutions that reflect their values. Fact check. The governor does have the authority to enforce state laws, but whether he can legally withhold grants for passing a resolution is a matter of legal interpretation. Local governments can assert their rights to make political statements or resolutions, but it is unclear if the specific actions of San Marcos truly violate state law. The threat to terminate grants is an aggressive response that could be challenged in court if the city decides to pursue it. The political rhetoric and framing. The claim, Abbott uses emotionally charged terms like cowardly attack and unacceptable to characterize Hamas's actions while focusing on one specific incident and condemning Hamas without equally addressing Israeli actions. The bias. The language used is emotionally charged, seeking to provoke strong reactions from readers. This rhetoric frames the situation as morally clear-cut and one-sided. The selective condemnation of Hamas without addressing the broader context of the conflict is a form of bias that simplifies a highly complex issue. The fact check. It is a fact that Hamas launched an attack on Israeli civilians on October 7th, which has been widely condemned. However, the rhetoric used here does not offer a balanced perspective on the broader context of the Israel-Palestine conflict. It fails to mention the ongoing cycle of violence, the occupation, and other factors that contribute to this complexity of the situation. Framing the issue in strictly black and white terms as cowardly versus acceptable ignores the wider humanitarian issues. The conclusion. The letter from Governor Greg Abbott contains biases in its framing, particularly by labeling criticism of Israel's policies as anti-Semitism and selectively addressing one side of the conflict. The legal claims regarding the violation of Texas law are somewhat overstated, as the resolution may not meet the criteria of a boycott under the law. The language used is charged with political rhetoric, potentially clouding the issue's complexity. The claims about the resolution's intent to economically harm Israel are speculative and not fully substantiated by the text of the resolution itself. Overall, while the letter makes valid points about Texas law and its stance on boycotting Israel, it contains some biases and oversimplifications that need careful examination. And while reading that to you, dear listener, it made me think of a question. Is having state or even federal law that prevents boycotting Israel a slippery slope? If Israel decided to start harming people, what keeps the U.S. from changing direction? As in, maybe boycotting and whatnot. Actually boycotting. ChatGPT responded, no, I haven't fact-checked or, had it double-check itself yet. The idea of preventing boycotts of Israel through state or federal law can indeed be viewed as a slippery slope in several aspects, especially in the context of civil liberties and freedom of expression. Here's a breakdown of the potential concerns. Freedom of expression and political speech. Concern: laws preventing boycotts of Israel, particularly those like the Texas law, could be seen as infringing on the right to free speech. Boycotts are often a form of political expression and a tool used to protest government actions. The slippery slope risk: if the government can mandate that entities, including local governments, businesses, or individuals, must not participate in boycotts against a foreign country, such as Israel, it could set a precedent for future laws that target other forms of political speech or protest. It raises the question of where to draw the line. Could such laws be used to suppress dissent on other controversial topics or foreign policy issues? Counterpoint: supporters argue that the laws are meant to combat anti-Semitism and protect economic interests. Boycotts of Israel are seen by some as a means of undermining U.S.-Israel relations So these laws are seen as a protective measure rather than infringement on free speech. Changing direction of Israel starts harming people. The law preventing boycotts could become problematic if Israel's actions towards Palestinians or other people led to human rights abuses or violations of international law. In such a case, it could be argued that the U.S. should be able to change its stance and withdraw support or take diplomatic actions, including boycotts, in response to those actions. The slippery slope risk: if the U.S. has passed laws that prohibit boycotting Israel, it might find itself in a position where its hands are tied when it comes to responding to negative actions by Israel. This could undermine the ability of the U.S. to change direction in its foreign policy as situations evolve and new information emerges. Counterpoint: proponents of these laws argue that Israel is a democratic ally of the U.S., and that these laws are not meant to prevent criticism of Israeli policies, but rather to counter any broad-based economic actions that could harm the country as a whole. They might argue that specific policies or actions can still be criticized without resorting to a full boycott of the nation. International repercussions and diplomatic ties. Laws that prohibit boycotts of Israel could complicate U.S. foreign policy and its relationships with other countries. For example, if Israel's actions were seen as a violation of international human rights, the U.S. might feel pressure from other countries or international bodies to take action, including joining in or supporting boycotts. The law would create diplomatic tension, especially if the U.S. finds itself aligned with actions that go against broader global consensus. The slippery slope risk: the law could potentially limit the U.S.'s ability to respond diplomatically to changing circumstances. If Israel's behavior changes dramatically and other nations or the international community begin to take stronger action, the U.S. might be forced into a corner, unable to participate in or even support broader global initiatives for justice or peace. Counterpoint: supporters might argue that such laws actually protect U.S. interests by ensuring that economic or political actions against Israel are not coordinated in a way that would undermine a strong strategic relationship with Israel, particularly in the context of security and regional stability. The role of public and private entities. The concern: some may argue that private entities, for example, individuals, businesses, or universities, should have the freedom to engage in boycotts or protests, including economic boycotts of Israel, if they choose to. By passing laws that restrict this, there's a potential of undermining individual or organizational autonomy. Slippery slope risk: if the government begins to restrict boycotts of one country, it could extend to other countries or political movements. For example, could the government later pass laws prohibiting boycotts against other regimes it deems critical to U.S. interests? This could limit the diversity of political expression and action in the U.S. Counterpoint: advocates of such laws argue that there are existing frameworks for protecting individuals' right to protest and express their opinions. They might also argue that public pressure, including boycotts, can be a dangerous tool if it undermines international relationships, or if it is based on misinformation or unbalanced perspectives. 5. Public opinion and political shift. The concern: what if public opinion shifts over time? If Israel's actions changed in ways that were increasingly seen as harmful, the government might be reluctant to adjust its stance because of the laws that prevent boycotts. This could limit the ability of the public to respond to perceived injustice. Slippery slope risk: if laws prohibiting boycotts become entrenched, they could stifle future shifts in public opinion, particularly if a majority of the U.S. population or international community came to believe that Israel's actions no longer aligned with the U.S. values of human rights or democracy. The government might be caught between upholding a law and responding to public demand for a shift in policy. The counterpoint: laws can be amended or repealed if they become incompatible with the evolving needs or values of the nation. Advocates of for these laws might argue that a significant shift in policy could occur through the regular legislative process. Conclusion: the slippery slope. While laws that prevent boycotting Israel are not inherently a slippery slope, they do present some challenges to the flexibility of U.S. foreign policy, individual freedoms, and democratic discourse. These laws could potentially limit the ability to adjust in response to changing global dynamics, human rights concerns, or public opinion. That said, There are safeguards, such as the possibility of amending laws or engaging in diplomatic measures that would allow for some flexibility. Nonetheless, the risk is that these laws might stifle the full range of political expression and action, especially if the situation in Israel or broader international relations changes in a way that calls for a reevaluation of U.S. policy. Thank you for listening to this all the way through. Feel free to drop a unicorn emoji in the comments to let me know you actually listened all the way through. And stay tuned for more, I guess, lunchtime, breakfast time, dinner time, whatever, readings of biases and fallacies within the things that we happen to come across.